The National Association for the Advancement of Coloured People was founded on February 12, 1909, as a direct response to racial riots in Springfield, Illinois. Such occurrences of anti-black violence, particularly lynching, were commonplace during this era. One particular reason for this were the so-called Jim Crow laws. These were a collection of state and local statutes which legalized racial segregation. One notable case of this time which emphasizes such segregation is Plessy and Ferguson 1896. Here, Louisiana's Separate Car Act required separate but equal accommodations for black and white passengers. Homer Plessy, an African American, attempted to test the constitutionality of the act and boarded a white carriage in New Orleans en route to Louisiana. He was then arrested and appealed to the U.S. Supreme Court on the grounds that racial segregation on interstate steamboat journeys violated the Interstate Commerce Clause of the Constitution. The court rejected these pleas with a 7-1 judgment on the grounds that separation did not make either race inferior to one another. The one dissenting judge, Justice John Harlan, was quoted as saying, "The Constitution is colourblind and neither knows nor tolerates classes amongst citizens." Following the violence in Springfield, 3 white liberals, Mary White Ovington, William English Walling, and Henry Moskowitz, called for a meeting to discuss racial justice and met in New York City. Some 60 people signed the call, of which 7 were African American. The founding objective was to achieve equality of rights and eliminate race prejudice amongst the citizens of the United States. With a strong emphasis on local organising, by 1913 the NAACP had established branch offices in such cities as Boston, Baltimore, Kansas City, Washington DC, Detroit and St. Louis. Further to this, membership numbers grew from around 9,000 in 1917 to around 90,000 by 1919. The primary avenue through which the NAACP communicated with its members was through the monthly journal The Crisis, created by W.E.B. Du Bois, the first African-American leader of the organisation and also the first African-American to earn a PhD from Harvard. The journal aimed to not only inform the American public about the horrors of racism, but also sought to report on stories and topics important to the black community. By 1925, circulation of The Crisis surpassed 20,000 readers. This increasing popularity led to many African Americans responding to the publication by writing letters to the editorial board. Some of these letters expressed readers' opinions about articles published, but many were personal testimonies to the racism suffered firsthand by African Americans. The substantial increase in the number of complaints of racial injustice persuaded the NAACP to divert resources into the creation of the Legal Defence Fund. The main 2 aims of this were firstly to have attorneys who could represent African American plaintiffs and fight segregation through the judicial system, and secondly to provide opportunities for African American lawyers to gain experience in litigation and become experts on the constitutional issues behind segregation. The NAACP then recruited top graduates from Howard University School of Law, the most esteemed black law school of the time. One particular attorney was Thurgood Marshall, who most famously argued the case of Brown v. Board of Education of Topeka.
The NAACP was early in targeting schools for their litigations. In doing so, their legal bullets were fired at the most sensitive parts of the Jim Crow system. The system separated the races in every imaginable area in the South. Restaurants, hotels, waiting rooms, buses and trains, even drinking fountains. However, white parents, like all parents, cherished their children above all. The ones who believed blacks to be inferior were sure that mixing the classrooms racially would hinder the learning process, and even worse, they feared that it could lead to interracial dating and marriage. If the segregation was to get punched, it had to be where it hurt the most. It is impossible to talk about the NAACP without mentioning Thurgood Marshall. The first Afro-American Supreme Court judge to be, Marshall laid the foundation to that career by playing a key role in the struggle for desegregation. In 1940, Marshall contributed to the founding of the NAACP Legal Defense and Educational Fund, LDF. One of these cases Thurgood Marshall and his fellow attorneys in LDF took was the one named Cipriel v. Board of Regents of University of Oklahoma. At Cipriel, a 24-year-old black girl was denied admission to the Oklahoma University on the grounds of race. In the US Supreme Court, Thurgood Marshall attacked the whole doctrine of separate but equal for the first time. He claimed that the public school segregation helps to preserve a caste system based upon race and color, to perpetuate the slave tradition. Although Marshall argued that separate never could be equal, the court clung to this doctrine and held that Oklahoma had to admit separate to the state university or build equal facilities for applying Afro-Americans. This was a setback for the NAACP, but the Jim Crow laws were to be attacked again later. Meanwhile, an Afro-American mailman named Herman Sweat was trying to enter the all-white law school in the University of Texas, Austin. Texas had just filed a plan to open an all-black law school in 3 rooms in a basement with a small law library. In 1947, Marshall argued the case before the Supreme Court. Here he was planting the seeds of the sociological arguments that the NAACP lawyers and social scientists would make in Brown v. Board of Education, with the permission of the Supreme Court. Marshall and the other attorneys in LDF decided the foundation was built and the time had come to bring down the de jure segregation once and for all. What later has been known as the landmark case of this desegregation was in fact made up by 5 cases combined under the name of Brown v. Board of Education. However, the case that has been known to the world was named after Oliver Brown, the father of Linda Brown, a 10-year-old who had to walk 6 blocks to the bus stop to ride her to the segregated black school 1 mile away, while a white school was just 7 blocks from their house in Topeka, Kansas. Oliver Brown tried to enroll Linda to the white school much closer, but was refused. The NAACP filed suit, but the district court ruled in favor of the Board of Education, citing the Supreme Court precedent set in Plessy v. Ferguson. The district court panel found that segregation in public education has a detrimental effect on black children, but denied relief on the ground that black and white schools in Topeka were substantially equal with respect to buildings, transportation, and qualifications of teachers. Thurgood Marshall argued the case before the Supreme Court. In the taxi on the way there, Marshall turned to his co-counsel, William T. Coleman, and said, "I have to be at my best today." Marshall rose to the occasion, and his and the other attorneys' work changed history.
During the trial in Brown, the NAACP adopted an innovative strategy of using social science experiments to demonstrate the psychological injuries that segregation was causing to African Americans. The lawyers used a doll experiment to see if children preferred dolls of a particular color, and it was shown that this was the case. This proved that the separate but equal doctrine was affecting the way that children see color. This helped the NAACP win the case, as this landmark decision stated that segregation in public education was unconstitutional as it violated the Equal Protection Clause of the 14th Amendment. Chief Justice Earl Warren stated in the judgment that education is more important now than ever, and that a child cannot be reasonably expected to succeed without a good education, and access to this is a right that should be applied equally. The impact of the decision in Brown is a controversial topic, with many regarding it as a fundamental turning point in the civil rights movement, whilst others argue that it had little impact on ending segregation in reality. The mass organising effects that were coordinated by key figures such as Martin Luther King highlighted the suffering of African Americans and the injustice of segregation. The Montgomery bus boycott in 1955 and 1956 and the Freedom Rise and sit-in movement of the 60s were the political face of this campaign for change. However, the decision in Brown was one of the key factors for the movement, and the NAACP were the legal foundation for subsequent challenges to implement desegregation decisions. Therefore, the case established a fundamental principle of law that using race as a way to discriminate was unconstitutional. This principle was crucial in igniting the civil rights movement, as before this no institution of national government had implemented this principle, and after the decision this idea became firmly endorsed in white culture for much of America. It became a controversial talking point for all, which shows the significant alteration the NAACP had made to life in America. However, many scholars have questioned how significant an impact the decision actually had on American life and the civil rights movement. The Supreme Court decided that segregation in public schools was not equal and that the separate but equal doctrine was unconstitutional. But the court also indicated in Brown 2 that states merely needed to make a prompt and reasonable start to desegregate schools with all deliberate speed. This made Brown an important moral victory, which highlighted the changing attitudes of America, but this weak compliance provision made many states unmotivated to change their school system, particularly in the Deep South, which has drawn the decision to significant criticism. For example, a decade after Brown, almost 98% of Southern black children were still being educated in separate but equal conditions, because many states chose to be unresponsive to the decision and chose gradual integration. Furthermore, by September 1967, 86% of Southern black students were still educated in segregated schools, with this figure rising further in the Deep South, with Mississippi reaching levels up to 96%. These figures help to highlight how the low level of desegregation that the decision brought in, as the weak compliance provision enabled states to get away with doing little to proactively instigate the change intended to be brought. Therefore, it appears the decision may have had little impact, thus lowering the significance of the NAACP in contributing to desegregation. In conclusion, the NAACP were extremely significant in desegregating education in America. The decision in Brown established a fundamental principle that the separate but equal doctrine is unconstitutional, and many people argue it is one of the most vital legal cases for ending segregation. However, many scholars have stated that the decision had little impact practically, and that it was more of a symbol for changing attitudes. On the other hand, what the decision did do was to ignite a civil rights movement that changed America significantly. This gives the decision and the NAACP significant impact, as it ultimately helped America progress to the implementation of the Civil Rights Act in 1964 and the Voting Rights Act in 1965.